So today we are going to discuss how long does it take for a federal lawsuit to be over. So, because in a federal lawsuit, so everything can be like a marathon rather than a sprint. And the timeline is shaped by the type of claim, as the parties involved, and the procedural tactics used by each side. And statistically, just surveys show that the average lawsuit may take between 2 to 3 years and no, especially in the U.S. district courts, and it can vary. So one law firm analysis of North Carolina, just in the federal cases, so they found it that a mean time of or just about 35 months. So it's for the average federal case. Some courts, especially in Virginia, so they have like a skyrocket docket, so it may just take maybe like 3-4 months less. So because some processes, especially discovery and the trial, so pretrial motions are expedited. But nationally, the administrative office of the U.S. District Courts reported that a civil case can take around 31.8 months to reach trial, and those numbers are average. So a straightforward contract dispute may end just more quickly, especially if you have like smoking gun evidence, while a complex suit involving just a federal agency can drag on for years. And this video explores two common scenarios: a defamation case involving the Westfall Act and a discrimination claim against a federal agency, because those two types are the most common. And we will explain how long each stage normally takes. We will also discuss why cases can stretch out and the dirty tricks defendants use to delay and the strategies for keeping the case moving. Let's consider example one. So defamation and the Westfall Act certification. Let's consider a certain background. So it's going to be like something specific which may happen to anyone. So when the plaintiffs use a federal employee for a defamation, for example, accusing an agency official of making a false statement that ruined one's reputation, and the United States may substitute itself as a defendant under the Westfall Act, and a federal employee acting within the scope of employment is immune from personal liability, and the lawsuit becomes a tort claim under the Federal Tort Claims Act, FTCA. And the typical timeline will be starting, of course, with administrative claims. So it will be like 6 months to 1 year. So before filing suit, as the FTCA requires just the claimant to present administrative claim to the appropriate agency and wait for a final decision or for 6 months to pass. And then you can just skip to the next stage. So filing the complaint and substitution. Substitution, by substitution, I mean as the DOJ, United States, may substitute. So this stage may take up to 2 months. As a complaint alleging defamation, so is filed in the federal court, as the Department of Justice will often certify that the employee acted within the scope of employment, and certification triggers substitution for the United States and transforms the case into a FTCA action. And then everything moves to the motion to dismiss. So they usually try to dismiss your case. And motion to dismiss ruling, it may take up to 9 months. So like 3 to 9 months. And the government may move to dismiss on jurisdictional grounds. So like failure to exhaust administrative remedies or just a briefing and a ruling can make months. And if the court denies dismissal, the case proceeds to discovery. And discovery is usually like 6 to 12 months. Of course, the parties exchange documents and take depositions and just might argue over privileges. And because the government has broad resources and usually just in these informal processes, the discovery can be slow. And they, of course, so getting paid, and they prefer to drag the process because the plaintiff usually gets frustrated, and that's what they want. Next stage usually comes to the summary judgment, and summary judgment motions, it's typically 3 to 6 months after discovery. And the government just often files a motion for a summary judgment, and the courts typically allow months for a briefing, so like hearings and a decision. And in civil cases, naturally, just summary judgment and other just pretrial motions contribute to a mean of roughly just 31.8 months from a filing to trial. And then it comes to the trial. So like a trial is very quick, so it can be like a one to 2 day trial or up to 3 weeks, depends on how many witnesses, how complex the case is. And if the case survives summary judgment, so it may be triggered to the bench, so since FTCA cases are non-jury. And then post-trial appeals. It may take up to 12 to 18 months. So either side can appeal to the circuit court, so which adds just another year or more. And according to the federal statistics, appeals can add an additional 18 months to case resolution. And everything is drags. So scope of employment certification, fights, and a plaintiff's offer exchanges with substitution, and just arguing the employee acted outside of the scope. And the courts may hold evidentiary hearings, so delaying the case by months. And the government privilege and discovery disputes, so everything. And the US can invoke executive privilege or a state secret doctrine and to resist disclosure. And litigation of these issues slows discovery. And when it comes to the FTCA limitations, as the damages are kept and there is no jury, so plaintiffs sometimes file parallel constitutional claims to preserve a jury trial. And these claims may be dismissed and appealed, so alongside the case. And you may try to use some strategic like tools to expedite it, but you should always comply strictly with administrative claim requirements to avoid a dismissal. Because at any stage, if you are asleep somewhere, if you make just a rash move and there is a mistake, slips out, so they may try to dismiss it outright. When you push for early scope employment discovery to challenge certification, so let's say if you can show the employee acted outside of the scope, the case remains against the individual and may proceed faster with the jury. And then when you seek an early settlement after the administrative phase, so like the government sometimes prefers to settle small claims rather than just litigate for years. Because when they are paying you something, like they're not paying it from their pockets, so they have a very large pockets because it's sponsored by a taxpayer just whole. And when it comes to discrimination claim against a federal agency, because sometimes defamation and discrimination cases are lapses, so some plaintiffs, some smart plaintiffs, so they usually litigate both cases at the same time. So if it involves defamation, so someone defames someone, and the basics of their second claim is a defamation. So let's say the DOJ have like two separate cases. It's better for them to settle both at the same time, and it's twice cheaper. So plaintiff, even if plaintiff may lose his first case, so he's still gonna press and move just forward, just fearlessly on the second one. So he will be furious, and that's not good for them, because they will spend a lot of time and resources on that. And the federal employees who believe so they have been discriminated against on the basis of race, sex, disability, age, or retaliation, just again generally just must follow an administrative process just under Equal Employment Opportunity Commission (EOC), so before suing. And the process includes counseling, a formal complaint, and often hearings before an administrative judge. And only after the EOC issues a final decision, or 180 days pass without one, so they may just, the claimant may just file a suit in a federal court, not before. And a typical timeline in a discrimination case, so since we already discussed the defamation, so we are just moving to the discrimination, and that we will look at both just from how long it's going to take just together, so if you're litigating it at the same time. So typical timeline for the discrimination cases, as usually everything starts with the EO counseling and complaint, which can just last up to 270 days. As employees must contact the EO counselor, so within the 45 days of the Discrimination Act. And counseling and formal resolution take about 30 days. And if an unresolved, the employee files a formal complaint, and the agency then has 180 days to investigate. And in EOC, just administrative judge may hold a hearing and issue a decision in, I think, months. And then, when it comes to the filing stage, so filing a suit, 6 months to a year after the complaint, after 180 days of receipt of the administrative judge decision, so the employer can file a civil action. And then it comes to initial litigation. First 3 to 6 months, the government answers the complaint and may file motions to dismiss or motions for extension of time to respond, and or for a summary judgment. And many discrimination cases are partially resolved at this stage. And for example, so some claims may be dismissed while others proceed. And if it's just adding up in discovery, so especially if your just raw report of investigation is incomplete, deficient, so you can identify it just right away. So then you can dig up into the agency's findings and you can challenge their investigation. So which you can do only in the discovery stage, which takes 6 to 12 months because agencies are very slow. And discovery in the Title VII cases can be extensive. So plaintiff must obtain the personal files, internal investigation, and the witness depositions. And of course, a comparator data, which is very just broad, so it can be like 10,000 documents. And agencies sometimes resist disclosure, just causing delays. And when it comes to the summary judgment motions and just the rulings on the administrative judge EOC level, so it's way more faster than in the federal court. So it may take like, it may be like twice faster. Usually like 4 or 10 months for a summary judgment if one party decided to file it. And employers often move for a summary judgment on each discriminatory theory. So like briefing schedules, hearings, and the ruling may stretch just close to a year. And a trial usually takes the same, because you should present all the facts. And if a claim survives, the case goes to the jury. And a trial is usually scheduled more than 2 years after the filings. And as administrative office note that the mean time, so from a filing to the trial in a civil case is about 31.8 months. And for the discrimination claims, and the timeline is similar. So some sources report that around like 8.5 months to dispose of a case just when it does not just reach a trial. But contested cases takes much longer. And the post-trial motions and appeals, because 90% of the cases are just losing everything, like plaintiff is losing outright because defendant is more prepared and it's hard to prove anything, especially since the standards are just skyrocketed, especially for harassment cases. And losing parties can file a post-trial motions and appeal to the circuit court. And appeals can often just add another 18 months, like 1.5 year. And delay tactics by the agencies, they are adding like roughly 6 to 8 months. So extensive administrative process, which they always do. So agencies sometimes use the AOC investigation period to just wear down of complainants. So they may just request extensions and conduct the inadequate investigations. And then when it comes to the scope litigation, so agencies may argue that certain acts are outside of the scope of the EOC, just a complaint, so forcing a plaintiff to file a new complaint and start the process over. And when you start the process over, when you're filing new claims, it's adding up just another 6 months. And then they usually stonewalling the discovery. So agencies may assert deliberative process privilege or just national security concerns to withhold documents. And they may also seek a protective order to limit depositions or for higher level officials. And a summary judgment overload. So agencies often file multiple motions for a summary judgment because they have their legal department. And they forcing plaintiffs to brief numerous legal issues and delaying resolution. And then when the plaintiff gets very frustrated, though, they may offer you a lowball offer. At some point, some cases have certain strategies to keep the case moving, especially so when you press for early EOC decision, so when you request an immediate hearing or a final action decision rather than just allowing the agency to investigate indefinitely, or when you just move to compel discovery, especially when the agency resists producing personal files or witness information. And the courts are receptive to motions demonstrating that the government is dragging its feet. And then when you seek bifurcation, so ask the court to bifurcate liability and damages. So like an early rulings on just liability can pressure just agencies to settle rather than litigate damages. And using Rule 16 scheduling orders, as the federal judges have authority under the Federal Rules of Civil Procedure 16 to control the pace of litigation. So a firm schedule for a discovery and the motions reduces opportunity for delay. And when you're agreed with ADR, so agencies sometimes agree to mediate, and the EOC and in many district courts offer mediation programs that can resolve cases a month or years before a trial, or they may just probe you on the facts just to see what you have. And judges they not always view delays as something like positive, so they not reinforcing it, because judges they have like an official statistics, and they getting evaluated by the average time of how soon each case closed. So judges have a broad discretion to damage their dockets, and they can sanction parties for unnecessary delays and deny extensions absent just a good cause. However, so federal courts are often just understaffed and have a heavy caseloads, which contributes to the slow march toward trial. But nonetheless, so judges may admonish a counsel for abusive tactics and grant motions to compel when delay is obvious. And in extreme cases, courts can deny summary judgment motions and just ultimately or award for attorney fees for motions to compel or discovery. And when you are aggressive but not too aggressive, so judge may appreciate it and it may rattle the defense side. So conclusion is very simple. Federal lawsuits are not quick, unfortunately. So even with specific tactics, even when you are very tech savvy, so it may be very slow, up to 5 years. And statistics show an average of 31.8 months. So from filing to a trial in the severe cases, and some cases, particularly those involving the government, take much longer. So non-jury FTCA cases, and such as defamation claims under the Westfall Act. So, and that type of cases proceeds through an administrative claim, so like motion to dismiss in a bench trial, and they can range 3 to 5 years. And discrimination suit against the federal agencies and EOC administrative phase can last 4 years or more, and if they reach a trial and appeal. And delays are aggravated by motion practice and in discovery battles and independent tactics. But the plaintiffs are not powerless. By understanding the process and just pressuring for strict schedules and challenging obstruction tactics, and so you can just keep your case moving and increase chances of a timely resolution. So if you want to learn more about litigation strategy, of course, cross-examination tricks and settlement negotiations, check out just other videos of this channel. So, and like, subscribe. That's it.